Revenge pornography is not about revenge, and it's not even about pornography for that matter. You may have heard the term revenge porn used to refer to a case where a person's private explicit images are published or otherwise shared without their consent. It is an egregious violation of a victim's right to privacy and is largely about an online abuser's ability to exert power and control over the well-being of their victim. Now, the term revenge porn, in my opinion, implies that an ex-partner posted private, intimate images without a victim's consent because they did something to upset their ex, and this was an act of retaliation. This implication that a victim did something deserving of revenge is inappropriate. The term fails to encompass other forms of digital sexual abuse where a partner did not necessarily act out of spite or even intent to harm, but rather out of a sense of entitlement to their partner's private content. As an attorney working with victims of digital abuse, I've seen cases where current romantic partners share images with friends without their partner's consent without any intent to harm. I've also seen cases where hackers steal and sell images online with the intent to make a financial profit. And yes, I've even seen a few cases where a vengeful ex intentionally publishes explicit images to humiliate and control their partner. The psychological effects of non-consensual image distribution are well documented, and these harms are not dependent on the sender's intent to harm the victim. Intent does not equal impact. Unfortunately, this need to prove ill intent has been codified into law in many states, but it forces a victim to prove that the person who posted their content without consent did so with vengeful intent, which generally means intent to injure, harass, or mistreat the depicted person. When explicit material is obtained without consent and is equated to pornography, this is also problematic. It both erases and harms rights of sex workers and adults who do consent to the creation and distribution of their content. Equating non-consensual material to ethical pornography also normalizes revenge porn as the genre of pornography and emboldens those to create, distribute, and consume such materials. We must remember that image-based sexual abuse is a crime, and it's a crime not because the content of the image is sexually explicit, but because the person who's depicted in the content never consented to private content being published. Rather than using the term revenge porn, consider using non-consensual image sharing, image-based sexual abuse, cyber-sexual exploitation. Unfortunately, the term revenge porn is still codified in legal language and is commonly used to describe these situations. These alternative terms may better describe the situation and its nuances, but if terms are unknown to victims and survivors, then there's a chance they won't know to search for these terms when searching for help. In my work, I do my best to balance language that people will understand, but also am careful to include alternative terms. It's important for everyone to understand that porn created as revenge is not porn. Pornography is consensual and legal material. It's constitutionally protected speech. I repeat, sharing explicit material without consent is abuse. Explicit material of those under the age of consent is also abuse. Porn, however, is not abuse, and this distinction is important. The language we use can inform our perspectives and values, and I hope the term revenge pornography becomes obsolete one day as these more accurate terms become more well known.